Hello and welcome to Legally Speaking with me, Tarun Nangia. Family law cases form a huge chunk of the 30 million or so cases that are pending in the country. And our country, which is so different socially and culturally, as you go across to many areas of the country, forming laws and seeing that they are applicable to all and just to all is a very difficult thing. Family law, in a sense, is a very tricky area also because relations are involved. And that is why Malvika Rajkotia, who's one of India's top family lawyers, has decided to write a book on this subject. The book has been published and she's here with us today to discuss the book. The book is aptly titled Intimacy Undone, Marriage, Divorce and Family Law in India. Here is the book. You can go and buy a copy for yourself. But today we are going to discuss the book, what motivated to write the book, and also the kind of situations that we face in India and different litigants face as far as family law and family cases are concerned. I also have Justice Jaspal Singh joining me on this episode. He is a former judge of the Delhi High Court. Welcome, ma'am, for sparing your time, and sir, welcome to the show, and thank you for sparing your time for today's discussion. To start off with, Malvika, what gave you this idea for writing this book?
Well, I don't know whether Judge Sab will bear me out on this, but my perception was that amongst practicing lawyers, family law was treated as something a little less serious and formal, and treated a little more lightly as a gharelu mamla which could easily be settled, and why aren't you settling? So in fact, as I've mentioned in the introduction, what prompted me to write was a comment by a judge to say that matters don't get settled because of lawyers. And I was hurt by it because I was appearing before him at that time, and I had actually begun writing a letter to the Chief Justice to try and explain the dynamics of this law according to me, and trying to put a perspective as a family lawyer to say that there is a difference between what we can do and what we do as under instructions. And that's what eventually grew into the book, to try and explain the dynamic of the subject and the fact that this is important, serious formal law which is at place, which is an important sociological aspect because of the sheer volume of cases.
But I want to ask you, and first let me congratulate you, because I've heard that your book has been shortlisted for the Tata Lit Fest first book award category.
Yeah, long list, yes.
Long list. So maybe it goes to the short list and you win. But after that, I'll get in Jaspal Singh into the news. Sir, I want to ask you is, when you look at family law in the country, and I know you would have decided so many cases, does it really get complicated in a country of 125 crore people because of huge social and cultural differences?
You see, it touches your court. It relates to your family, your children, your in-laws, the society at large, because unfortunately we still feel that divorce is something which is very bad. It shouldn't happen. Or that the wife is living separately. Oh, there must be something wrong with her, not with him. Now, that unfortunately is still prevailing. And that makes it very difficult for the parties involved and the relatives around to reconcile to the situation that the woman or the husband has gone to the court. But then I know Malvika. I was a matrimonial judge myself for pretty long. Malvika was a young, dynamic lawyer. Not that she is not young anymore. And full of fire even at that time. I'm so happy she has come up with this book. She has a lot of experience on this subject. And incidentally, or I may say, I have also written a commentary on Hindu Marriage Act. So we are on the same platform for the... it's very unfortunate litigation.
So, taking a cue from you, Malvika, although I would hate to call you that, but you are known to be one of India's top divorce lawyers, if I may.
I'm most grateful that, I don't know who says that, but it's
Yeah, I came across this fact. I don't know if it is true that it is said that looking at the pendency and the situation of family and divorce cases in the country, Malvika wrote a letter to the Chief Justice of the Delhi High Court, but never ended up posting it. Is it true that you never ended up posting it?
No, never, because that's what became the book.
That's what became the book. So you thought, why not write a book and say...
I started keying it in. It was angry immediately, and then I wrote a whole lot of reasons about this is the perception and this is the fact, and this statement came from the judge with this perceptive, but the fact is, and so on and so forth. And firstly, it became longer than a letter should be, and then I just, took it from there.
So simply why not write a book? Justice Singh, what do you think of such work of scholarship? Because as a practicing lawyer, writing a book necessarily would never give you, there are so many top lawyers who don't care to pen a book because the practice is doing well. What does it take for somebody to take one's time out and write a book? What do you think about such an effort?
It's a great effort. And I tell you, it's a great service to the society at large.
For all the students of law? Or
Not only the students of law, the makers of law also. Now, if you look into this book, the subjects and the range, it will be a wonderful basic work for even the lawmakers to make certain changes. And for those, most of the judges, that male chauvinism is still there.
Yes.
So it's an eye-opener and a warning also.
It's an eye-opener, as Justice Singh says. Malvika, I would like to, you have highlighted as how family law has moved from looking at marriage through extreme reverence to acknowledging a more contractual arrangement, because sacredness cannot obliterate an individual right to exit a wedlock for a just cause. Could you explain it for viewers and potential readers of your book?
Right. So I don't know whether I've used the word just cause, but the point is in 1977, Justice Avid Bihari Rotagi, in fact, the context of the case is my own uncle's case, Mahinder Pal Singh Man versus Kulwant Kaur. And he filed for divorce and it was refused. And Justice Rotagi quoted the famous book by Herbert Spencer called Holy Deadlock, and said that here is a case which has a tinge of sadness in it. Very clearly, it's tragic, yet the law doesn't allow me to dissolve this marriage because I don't see that she is cruel to him, and I find that his wanting to exit from the marriage is taking advantage of his own wrong. And then I've said that to my mind, he was my mamaji, my sakka mamaji. And I said that I didn't see him as doing any wrong. He was a gallant, highly decorated soldier and so on and so forth. That case from 1978 onwards, that we haven't moved away from what is called the fault theory. Whereas the fault theory, the same book, Holy Deadlock, created waves in England and led to the Matrimonial Reforms Act, which made it easier for a couple to exit marriage. Sometimes nobody is at fault. But it's just, so the author says that, look, you can change your mind about a career. You can join the army and exit. And here is a situation where the door clangs shut in your marriage and you can never change your mind. That, there's something wrong.
Okay. And I'll go across to Justice Singh. Sir, Malvika has written that the present legal system, some of the elements may have elements of primitive patriarchy at its worst and benevolent patriarchy, patronage at its best. Yeah. How would you see this statement, and also, give your analysis on the current situation?
You see, she was just referring to a case.
Yes.
A matter went to the Supreme Court. Parties were having litigation. Number of other cases too. 18 years of separation.
18 years of separation.
And still the Supreme Court, in its wisdom, did not think of exercising its jurisdiction to dissolve the marriage.
Yes.
Now, what is the use of it? So, it is not always the law. It is the flaw here in the mind of the judge which plays havoc.
And I'll take this point ahead from here, because Malvika in a book also mentions that divorce litigation can be extremely exhausting. Malvika, can you please briefly explain how...
Yes, I've said exhausting, draining, emotionally and financially.
Yes.
Litigation is expensive. Any kind of litigation is expensive. But emotionally, what it takes, because it's not like a commercial matter where, you can still go home at the end of an evening and, come back to a family. It's your life itself which is unraveling. And there is no home to return to for Sukha because you're going through all of that. That's exactly what I mean by it. And somewhere, I can understand there is a lot of litigation which carries on. So there are two sides to it. One is that do you succumb or get beaten down by the system to settle for far less than is your legal due in a financial entitlement or in terms of a parenting arrangement. And the other is you fight it through. And a lot of it has to do with the litigant themselves. Some of them will say, we are going to take it through. And yes, important developments in law happen from that perspective as well.
Okay.
So all law, according to me, happens when the fight carries on. So there is a purpose there too. We need important precedents.
On this note, we'll take a short break and we'll be right back. Welcome back. Just before the break, we were discussing that how family law as such has developed in the country, and also women have suffered due to certain, what you can say, patriarchal systems prevailing in our country, and how especially in divorce cases do women suffer on account of the patriarchal system that has prevailed in our country for what you can say, centuries together, and how things have begun to change for the better, but still a long way to go. I'll go across to Justice Singh on this account. Malvika highlights in her book, and I must read out this point to you, that women's conduct during marriage and also during divorce proceedings can affect her alimony and how much rights to alimony she gets. Even the custody of children can be affected if sexual immorality is alleged. Do you think women suffer on account of certain biases that exist in our society?
You see, the basic law as far as the adoptions are concerned or custody is concerned, the primary responsibility of the court is to look into the future of the child.
Yes.
Now, if the husband or the father in this case is well-read, well-educated, well-placed, and unfortunately the wife is not,
Yes.
then the court will keep on thinking, where does the benefit of the child lie? With the father or the mother? In that case, those motherly instincts, that love of a mother for the child becomes subservient.
Yes.
That is how the case law goes. It is primarily the benefit of the child. But I may tell you something, she touched a very important point. There is a Punjabi writer, Tibana, she got Sahitya Academy Award for Eho Hamara Jeevna.
Yes.
It will show you the life of a woman, the travails, the problems, the difficulties she faces, especially in Punjab atmosphere. But that is true with regard to all the places. Women are still, I'll say, still at a great disadvantage. If the improvements have happened, say she has a lot of experience in Delhi, I'm making some statement. I hope she'll agree. Most of the family judges now are women.
Yes.
Is it because they are there that there is a little change in perception?
That's a very...
Because they are the sufferers themselves. They'll look into the law in a positive way, how to help a woman.
That's a very important
point. That may be
point.
a reason.
And we move on to the next point which Malvika made in her book, that there is no legal system or provision for equal property distribution, and financial settlements can be influenced by the judge's perception of who is to blame for the breakdown of marriage. So this is a very, what you can say, a grey area for a lot of people. How does this affect divorce cases?
Distribution of property?
Yes.
Well, there's another problem. In one nuclear family, sometimes there's just not enough in the kitty to actually be divided. So either there's too little money or no money, or there's so much of it that even that leads to very fierce fighting. And that, in fact, becomes a problem between how much is her entitlement and how much will judges then presume that it's too much.
Yes.
So in the West is the idea of alimonies being related. Firstly, in the West, couples where there's not much money, there's a new trend, which is that you don't apply for divorce and you continue to live separate lives within the same marriage. Socially, this country, we are not ready for it, and that's fine. I'm not passing a value judgment either way, either for that or this. It's a practical thing. But where there's a lot of money, then comes the question of how much is need and how much is want. Now, abroad, it must take care of basic needs and reasonable wants. And needs and wants are pegged to tenure of marriage. So a short tenure marriage with no children will give you a smaller alimony amount, whereas a long marriage of 30 years and so on with children, etc., will obviously be equal to the investment in the marriage. But there are no clear rules here. It tends to be very subjective. It tends to be a very broad, unclear margin of discretion kind of an exercise. So my suggestion has been, what I've tried to do is that it's very easy to have formulas to make sure that certain basic things are taken care of almost immediately.
Yes.
The High Court has passed certain judgments with Justice Midha, which have put these in place, but the rest of the country still needs
That's a very important point. Justice Singh, as Malvika has taken these points in her book, I would want to, taking on from her point which she made, I want to ask you, there is a case of a lower middle class family and there is a case of a super rich family. We have seen that if you take the super rich or the rich segment of society, in marriage a woman is accustomed to certain privileges. But while the divorce is on, the woman is asked to live within a particular amount, which is much lesser than even what she could dream of being used to while she was in marriage.
Yes.
Do you think this is where the woman ends up getting the short stick, and the judges, due to certain perceived morality, would say that if the world can live in... This is adequate. So, what the judge perceives as adequate, can that be a problem? Because, he would look from his socialization and the woman would live in a totally different segment of society and her socialization would be different. Do you think that's an issue?
You see, there is Section 27 of the Hindu Marriage Act,
yes,
which provides for permanent alimony
yes,
in case of divorce. Now the courts are giving judgments, and it's now a well-established principle that she is also entitled to live with the same standard with which she was living when she was with her husband.
yes,
So that principle is now well settled.
yes,
The problem sometimes is that the husband suppresses his income.
Husband suppresses the income.
The Delhi High Court has amended the rules of Hindu Marriage Act. Fortunately or unfortunately, they were framed by me. And one amendment is that you file your affidavits
Yes,
showing as to what is your total income, what are your assets, so that the court comes to know as to what is the financial position of both the parties. There is a very recent judgment, 2017, where they say where there is some ambiguity, then the court should resort to Section 10 of the Civil Procedure Code.
Yes.
That means record the statements of the parties. Now that is an improvement.
That's an
So the courts are working on
Courts
it.
are working.
But ultimately, of course, it's your perception.
Perception, Malvika, and this is a pertinent issue, and you had a point to make. Is it really an issue that during divorce proceedings, if a woman is used to certain kind of a lifestyle, she may not end up getting that alimony because the process of law is abused?
See, process of law may not be abused per se, because if she is persistent, it does translate. Question is the time taken. So, for example, the whole game in terms of numbers I've put, where it's a ratio of, if there is 3 alimony judgments, which is alimony is when the divorce and proceedings are done, as opposed to 20 interim maintenance.
Yes.
So the law and the jurisprudence is developed around interim maintenance rather than alimony, which is final.
Yes.
Because most parties get exhausted.
Yes.
Because of how long it takes.
Yes.
So it's not abuse per se, it's the systemic issue. If we could have faster procedures, then yes, we could perhaps have quicker, better development of law.
Justice Singh, I want to ask you, that Malvika has penned down this book, and she also suggests a lot of changes that are required in her observations. If I want to ask you, if there are some 2 or 3 things that you would like to see changing, or some laws that should be, what you can say, incorporated into the acts, do you think, what do you think needs to be done to improve the system as a whole?
You see, I don't know, the society is prepared. The lawmakers are not. It is irretrievable breakdown of marriage.
Yes.
Why that principle is not being introduced into the marital laws?
Yes.
If they can't live together, it's fine. Let them part ways. But still, you regard it as a sacrament, as something very sacred. We are, as Malvika has said, moving towards a feeling that it is partly for the present, contractual also.
Yes.
The thing is, actually, let's come out of that sacrament.
Yeah.
It's not working anymore. Muslim law treats it as a contract.
As a contract.
Yes.
But we don't. And as I told you, that 18 years of litigation, criminal, civil, matrimonial, and yet the Supreme Court says no. We will not exercise our power under Article 141 of the Constitution.
I take your point. And to end with the show, Malvika, I want a wish list from you. 3 or 4 things that you want changed, and you would, what you can say, make your submission to the lawmakers and the society at large of what you wish to say.
Well, one straight away, what Judge Saab said. For example, irretrievable breakdown is also will streamline. Half our trial system gets clogged with trying to prove fault. Yes. The moment it's irretrievable and it's established that it is irretrievable, you've got trial out of the way. Yes. Then you are only focusing on finance and children. That takes care, that's half the work of the family court taken care of.
Yes.
Things will move faster. Then once things move faster, we can actually have more fair judgments with regard to equitable distribution of finance. So once the core, which is actually, it's rotten now, it's done.
Yes.
Do away with it.
Yes.
Then let's deal with what really matters, the children and fair distribution of property.
Yes.
That's it.
So Malvika has raised 3 very pertinent issues: irretrievable breakdown of marriage, children, as well as alimony. For the rest of the issues on family law, you must read a book, which is Intimacy, Undone, Marriage, Divorce and Family Law in India. That's it for today. Thank you so much, Malvika, for sparing your time and joining us for today's episode. Justice Singh, as usual, thank you so much for giving us your time.
So nice.
That's it for this episode. Thank you so much for joining in. Thank you.